It was only a joke!
He said it was just a joke. The court forced him to sell his farm. This is the story of one of the most famous contract law cases ever decided. Lucy versus Zehmer. Welcome to Law Review Hub. Today we're exploring one of the most famous contract law cases ever decided in the United States. A conversation, a handwritten note, a farm worth $50,000, and a man who later claimed he was only joking. But this case would eventually help define one of the most important principles in contract law. Can a person be legally bound by an agreement they never intended to make? Let's find out. Before we begin, let's talk about the property at the center of this dispute. The case involved the Ferguson Farm, a large property in Virginia consisting of approximately 471 acres. For years, the farm had attracted the interest of a local businessman named W.O. Lucy. This is W.O. Lucy. Lucy was a businessman who had wanted to purchase the Ferguson farm for quite some time. He believed the property had significant value and had previously expressed interest in buying it. But despite his efforts, no agreement had ever been reached, at least not yet. This is A.H. Zehmer. Zehmer was one of the owners of the Ferguson farm. He also operated a local restaurant in Virginia. Unlike Lucy, Zehmer was not actively trying to sell the property. At least that is what he would later claim. This is Mrs. Zehmer. She and her husband jointly owned the Ferguson farm. Although she would not play a major role in the discussions that evening, her signature would later become one of the most important facts in the entire case. And that signature would make it much harder for Zehmer to argue that everything was merely a joke. Our story begins on the evening of December 20th, 1952. Lucy visited Zehmer's restaurant. The two men sat down together and began talking. At first, it was just an ordinary conversation, but before long, the discussion turned toward the Ferguson farm. Neither man could have known that this conversation would eventually end up before the Supreme Court of Virginia. At some point during the discussion, Lucy made a bold statement. He looked at Zehmer and said, "I bet you wouldn't take $50,000 for that place." It was a serious amount of money, especially in 1952. But Zehmer immediately responded, "Yes, I would too." At first the exchange may have sounded casual, but the conversation did not end there. In fact, it continued for approximately 40 minutes. The two men discussed the property, the price, and the possibility of a sale. Eventually, Zehmer reached for the back of a restaurant guest check. Then he picked up a pen, and he began writing. On the back of that small receipt, Zehmer drafted an agreement stating that he and his wife would sell the Ferguson farm to Lucy for $50,000. At that moment, what began as a conversation was starting to look very much like a contract. Lucy reviewed the agreement. Then he noticed something important. Only Zehmer had signed the document. Because the farm was jointly owned by both Mr. and Mrs. Zehmer, Lucy wanted additional protection. So he made a request. "Your wife should sign it too." Mrs. Zehmer was called to the table. She reviewed the document. Then she picked up the pen and signed. At that moment, Lucy believed the deal was complete. There was a written agreement. There were signatures, and there had been a lengthy negotiation. Everything appeared legitimate. Satisfied with the agreement, Lucy left the restaurant. He believed he had successfully purchased the Ferguson farm. As far as he was concerned, the transaction was complete. But the story was far from over. Soon afterward, Lucy attempted to move forward with the purchase. That is when Zehmer made a surprising claim. According to Zehmer, the agreement was never intended to be real. He insisted that everything had been a joke. The discussion, the writing, the signatures. All of it, he claimed, was merely in jest. Lucy strongly disagreed, and the dispute eventually made its way to court. The court faced a simple but important question. Did the parties form a legally binding contract? Or was Zehmer correct that the entire transaction had been a joke? To answer that question, the court relied on a fundamental principle of contract law known as the objective theory of contracts. Under this approach, courts generally do not focus on secret thoughts or hidden intentions. Instead, they focus on outward actions and words. The law asks, how would a reasonable person interpret the situation? The court examined all of the evidence. The negotiations lasted approximately 40 minutes. A written agreement was prepared. Changes were made to the document. Mrs. Zehmer was brought in to sign, and both parties acted as though they were completing a serious transaction. From Lucy's perspective, every objective fact suggested a real agreement. The court ruled in favor of Lucy. The agreement was enforceable. Whatever Zehmer may have privately intended, his outward conduct communicated a genuine offer to sell the property, and the law held him to it. More than 70 years later, Lucy versus Zehmer remains one of the most important cases in contract law, but its lesson extends far beyond law school classrooms. For law students, this case demonstrates the objective theory of contracts. The court did not focus on what Zehmer secretly intended. Instead, it focused on what a reasonable person would have understood from his words and actions. This principle continues to shape contract law today, but there is also an important lesson for everyday life. Many people believe that what matters most is what they meant. The law often sees things differently. What matters is how your actions appear to others. If you make a serious offer, put it in writing, sign a document, and behave as though an agreement exists, the law may hold you responsible for those actions, even if you later claim that you were joking. Lucy versus Zehmer reminds us that words have consequences, signatures have consequences, and actions have consequences. In both business and personal life, it is important to understand that agreements are not judged solely by what we think. They are judged by what we say, what we do, and how a reasonable person interprets our conduct. A simple conversation in a restaurant became one of the most influential contract law cases in history, and it teaches a lesson that remains relevant today. Be careful what you agree to. Be careful what you sign. And never assume that calling something a joke will erase its legal consequences. In the end, Lucy v. Zehmer was never really about a farm. It was about trust, responsibility, and the idea that our actions can speak louder than our intentions. That is why this case is still studied in law schools around the world, and that is why it continues to matter today. Thank you for watching Law Review Hub. If you enjoyed this case review, please like, subscribe, and leave a comment below. And let us know which case you'd like us to cover next. We'll see you in the next case.